Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is how to avoid costly mistakes when writing an amendment. So, when a buyer and a seller contract to sell a house, they have a binding contract, the terms of which bind the buyer and the seller to what they agreed to in the actual binding purchase and sale agreement. However, those terms may be changed by agreement between the parties, the buyer and the seller, on an amendment. So when you draft an amendment and it is fully executed, meaning fully signed by the buyer and the seller, then whatever is in that amendment adds to the contract or changes the contract if something that is amended addresses something that had already been agreed upon. So, a couple of things with writing amendments. Number one, if you just draft an amendment and it is never signed, it is not part of the contract. It's as if it does not exist. Only binding amendments get numbered. So once you're under contract, when you go under contract, exhibits are lettered A, B, C, D, E, and then amendments, which only fall into place after you have a binding contract, are numbered 1, 2, 3, 4, 5. So proposed amendments, if you propose an amendment number 1, but it is never agreed upon, it is never fully signed by the buyer and the seller, and later on down the road you propose another amendment that deals with a separate issue, that is still going to be amendment number 1, because even though you proposed amendment number 1, if it was never executed, never signed, it's not part of the contract and it doesn't exist. Therefore, amendment 1 does not yet exist. So remember that when numbering your amendments. But let's get back to the amendments themselves. So you could do an amendment that adds to the contract that has already been agreed upon. Okay, so here's an example. Let's just say that the buyer and the seller are under contract with a close date of 30 days. And for whatever reason, the buyer needs an extension. The needs a 2-week extension. The seller says, sure, I'll be more than happy to give you a 2-week extension, but I want you to put in more earnest money. So the buyer says that's fine. So you're going to do an amendment that says, number 1, new closing date shall be blah, 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 which is 2 weeks later. Number 2, buyer's earnest money to be X amount of dollars. Now, if you just leave it like that, let's say in the original purchase and sale agreement, the buyer's earnest money was $3,000. And let's say they negotiated and the seller is going to require an additional $1,000 earnest money for the privilege of agreeing to extend it for 2 more weeks. And the buyer is fine with that. So in your amendment, if you put, again, new closing date shall be blah, blah, blah. Number 2, buyer's earnest money shall be $1,000. Well, what does that mean? Does that mean it's an additional $1,000? What happened to the original $3,000 in the purchase and sale? Or does that mean it is an additional $1,000 for a total of $4,000? You need to be very, very explicit and spell it out. So what you would do is you would say in the amendment, item number 1, again, is going to be new closing date of X amount of dollars. Item number 2, per paragraphs A7 and B7 in purchase and sale agreement, buyer to remit an additional $1,000 to holder for a total earnest money deposit of $4,000. You want to make sure to address, since the topic of earnest money has already been addressed in the binding contract, and now you are changing it or altering it. You need to specifically address, is this adding to the $3,000 they had already put in, or is this in place of the $3,000 they had already put in? You need to spell it out. So let me give you another example. Let's say buyer and a seller are under contract, and buyer has during the due diligence period, the buyer and the seller have an amendment to address concerns, And let's say this one's getting a little complicated, so pay attention. The seller agreed to do the repairs. However, there was a special stipulation. Again, this is a maximum one special stipulation that we encourage agents to address the potentiality of a seller not performing those repairs. You need to give the buyer options as to what to do. So let's say buyer and seller on an amendment to address concerns, seller agreed to do repairs. But there was a special stipulation that stated all parties agree that the repair work contemplated and agreed upon herein shall be completed not less than 5 business days prior to the closing dated of whatever. All work shall be completed by vendors licensed in the state of Georgia through proper licensing board to complete the work required herein. Seller shall provide the buyer at least 5 days prior to closing evidence of vendors licensed to do the work, invoices, and paid receipts for the work completed. Now here's the part. Should seller not complete the work required herein at least 5 days in advance of closing, buyer shall have the right to either immediately hire vendors of buyer's choice and have the work completed at seller's expense to be paid at time of closing from the seller's proceeds, or terminate the contract agreement with full refund of all earnest money deposit. So what that is saying is that seller agrees to do the repairs 5 days prior to closing. Seller hasn't done them. At that point, the buyer hires a vendor, gets invoices, sends them to the closing attorney, and those invoices get paid from the seller's proceeds at closing. That's already been agreed to, signed, sealed, and delivered on the amendment to address concerns. Now, let's say the something else changes financially. Let's say the appraisal comes in and the buyer and the seller agree to a lower sale price that was already agreed to and negotiated in the purchase and sale agreement. So you have an amendment that addresses the sale price and says all parties agree new sale price of X amount of dollars. Now, we're dealing with money here. So just because, and then you go to closing. So and you make sure the closing attorney and the lenders get all amendments, especially having to do with money and sale price. So let's say that now you get to closing and the closing attorney sees all these amendments and the closing attorney, the lender, everybody does it with the new sale price. And then all of a sudden on the HUD statement, there is this subtraction from the seller's proceeds going to whatever vendor based on those repair invoices. And the seller says, what on earth is this about? I didn't agree to that. And the buyer says, yes, you did, because you didn't do that repair work. And in that amendment to address concerns, it stated if you didn't do it, that you were going to pay a vendor out of your proceeds. And the seller is thinking, no, that was all fine and good. However, once I agreed to a lower sale price, I didn't agree to that financially either. I thought that was all taken care of in the new sale price, that all the other financial deals and negotiations were done. Well, that was not addressed in the amendment. So if that is the intent of the parties, if you're changing the sale price or anything financially, and the buyer and the seller do agree that, let's say the appraisal comes in less than sale price, but instead of that money coming out for repairs, the seller just agrees to an even lower sale price. What you would have to address in the amendment itself is you would say, number one, new sale price of X amount of dollars. Number two, all parties agree that amendment number one, amendment to address concerns, is no longer part of this contract. In other words, if something had been agreed to and now you are taking it away from the contract, you need to address it that the parties agree it is no longer part of the contract. If that item, that money that's paid to a vendor at closing from the seller's proceeds, if that is not specifically addressed in a future amendment, it is still fully intact in the agreement, in the binding contract between the buyer and the seller. So those are just a couple of examples. Bottom line is, when you guys are working with buyers and sellers and you have a binding contract, and then based on circumstances or whatever happens and further negotiations take place especially dealing with money, whether it be sale price, whether it be payment to vendors of buyer's choice, whether it be a change in earnest money, whether it be a change in a seller's contribution to buyer's closing costs. Make sure that you reference that topic that has already been agreed to. And in the amendment that the buyer and the seller are going to assign, you either state that that is in addition to what had been agreed to, replacing what had been agreed to, or what had been agreed to is no longer part of the contract. So I hope this contract tip helped you out. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.